बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलाम वालेकुम नाज़रीन। कानूनी शहादत आर्डर में आज हम डिस्कस करेंगे आर्टिकल 143 से 149 आर्टिकल जो कि डील करते हैं चेक्स ऑन द क्रॉस एग्जामिनेशन। इट इज़ द ड्यूटी ऑफ द कोर्ट टू डू जस्टिस नॉट ओनली विद द लिटिगेंट्स but also with the witness appearing before it. Doing justice with the witness means giving full protection to the witness against the erroneous powers of the cross examination, as it is the witness who bear great importance in the dispensation of the justice. In this connection, Kanun Shahadat Order has provided certain checks on the unfettered power of the cross examination. Article 143 courts to decide when questions shall be asked and when witness compelled to answer. Checks on unfettered power. Cross-examination has a wide scope as compared to other modes of the examination of the witness. A cross-examiner is allowed not only to ask questions which are related to the issue but also to inquire about various irrelevant details. So there has to come checks on the erroneous powers given to the cross-examiner by the order. These checks are enumerated in the various articles of the order. Court's interference. Article 143 protects a witness against improper cross-examination. It is the court which decides that what amount of improper cross-examination, meaning thereby that which witness shall be asked and when witness shall be compelled to answer those questions, but the court is bound to regard the consideration mentioned in the same article while exercising its discretion. The object of this article is to prevent the unnecessary seeking up of past history of the witness when it throws no light on the question at issue. It also protects the witness against reckless and unjustifiable cross-examination under the guise of impeachment of the credit of the witness. क्वेश्चन विदाउट रीजनेबल ग्राउंड आर्टिकल 144 इस हवाले से ये कहता है इनॉमरेट बाय द इम्पोजिंग a restriction that no imputation is to be leveled against the witness unless and until the cross examiner has reasonable ground to do so. For illustration, a witness of whom nothing whenever is known is asked at the random that whether he is a decade. Here there is no reasonable ground for such question and this type of question must not be allowed. Court's power under Article 144 ये कहती है if the court is of the opinion that any such question was asked by any advocate without reasonable ground, it may report the matter to the authorities for disciplinary action against such advocate and counsel. Article 146 इस सवाल से ये कहता है indecent and scandalous questions are not allowed. The order empowers the court to impose certain restrictions in order to avoid indecent and scandalous questions. But the court cannot forbid such question if they relate to the fact in issue. अगर वो fact in issue से relevant होंगे then ये allow हो सकते हैं. Cases of rape, legitimacy of child, etc. as observed in a foreign case, what is relevant cannot be scandalous. In case of defamation, libel and slander, Article 147 इस वाले से कहता है in a case of defamation under Article 147 binds the court when it is of the opinion that the case so brought before it is true and genuine, not to permit any question which would injure the character of the witness, the person in respect of whom such defamation has or is alleged to have been made, any other person in whom the witness is interested, whether dead or alive. Exception to this rule, such question may be allowed for asserting the truthfulness and genuineness of the case सो ब्रॉड बिफोर द कोर्ट. अगर केस के मेरिट्स की अगर बात करें रेलिवेंट इन इशू हो अगर ये क्वेश्चन तो देन ये क्वेश्चन अलाउ किए जा सकते हैं. अदरवाइज कोर्ट इस पर जो है चेक्स लगाएगी और ये क्वेश्चन अलाउड नहीं होंगे. इंसल्टिव एंड अनोइंग क्वेश्चन अंडर आर्टिकल 148 ऑफ द ऑर्डर इज मैंडेटरी इन नेचर, बाइंडिंग द कोर्ट टू कीप अ चेक ऑन इंसल्टिव एंड अनोइंग क्वेश्चन. किसी किस्म के ऐसे सवाल जो कि तज़हीक अमेज हो और क्रेडिबिलिटी के विटनेस की क्रेडिबिलिटी और मोरालिटी को अगर इंजर्ड करने के हवाले से किए जाए तो कोर्ट इनको जो है मना कर सकती है. बाय नॉट अलाउइंग देम टू बी आस्क्ड इवन द अपरेंटली प्रॉपर क्वेश्चन मस्ट आल्सो बी thoroughly scrutinized by the court in order to make sure that the witness is not subjected to unreasonably insultive questions. Other checks, the court is bound to keep the cross examination within legitimate limit. when the court finds that cross-examiner is putting undue pressure which causes harassment on witness, the court has power to stop cross-examination, abuse of procedure in the matter of cross-examination, which increases the cost of litigation without any corresponding benefit, should be checked by the court. Where the examination appears to be unduly protected, the court has the power to control the cross-examination. Apart from Kanuni Shahadat order, the court may stop the repetition of the question already answered by the witness. Any question put to the witness on which he is not competent to speak and had no opportunity to know may be allowed. Grouping of several questions into one long composite question and demand of an answer yes or no, which can create confusion in the mind of the witness, must not be allowed. The court may in all cases disallow any question which may appear vexatiously. ये तमाम की तमाम डिस्कशन थी कि कौन कौन से सवालात क्रॉस एग्जामिनेशन के दौरान विटनेस से किए जा सकते हैं और कौन से सवालात जो हैं अदालत मना करती है कि क्रॉस एग्जामिनेशन के दौरान विटनेस से नहीं किए जा सकते। ये तमाम चेक्स जो हैं कानूनी शहादत आर्डर ने बताए हैं और बयान किए हैं, जो कि क्रॉस एग्जामिनेशन के दौरान कोर्ट की ड्यूटी है कि वो इन पर पूरी तरह से नजर रखे और इस तरह के सवालात को अलाउ ना करे। अब तक के लिए इतना ही। अल्लाह निगहबान।